Couple headlines with legal implications. The San Mateo County District Attorney's Office is declining to file charges against former boxing champion Iron Mike Tyson for his physical involvement in a physical altercation with another passenger on a JetBlue plane at the San Francisco airport. Now, Tyson is the youngest person in history to win the heavyweight title in boxing and can be seen in the video landing several punches on a passenger identified as, if you can believe it, Melvin Townsend III. Who has a name like that? A spokesman for Mike Tyson explained that Townsend was behaving aggressively and had thrown a water bottle at Tyson. Who the hell would do that against Iron Mike? And was visibly intoxicated as well. While neither of the men will be facing criminal charges for the fist fight, that may not be the end of this dispute. Townsend has retained Matt Morgan, an attorney at Morgan & Morgan, who released a statement condemning Tyson's reaction as excessive and defending his client as an overly excited fan. Townsend denies throwing a water bottle at Tyson. Why did Mr. Townsend lawyer up if there's no charges being filed? There's a lot of reasons why that might be, but one that we'll discuss today is the possibility of a civil lawsuit being filed by Townsend against Mr. Tyson. While most people are familiar with the crime of battery, less people are familiar with the civil equivalent known as a tort. A tort is a wrongful act or infringement of a right that can lead to civil liability. There are a variety of different types of torts. Battery being specifically defined as an intentional tort, meaning it is a wrongful act that was done on purpose. While criminal charges can certainly help prove intentional tort claims such as battery, they may not always be required. One of the most famous examples of a person being acquitted during a criminal trial to later be found liable in a civil lawsuit is the infamous 1995 case of California versus O.J. Simpson. Simpson was acquitted at a jury trial of 2 counts of murder on his ex-wife Nicole Brown Simpson and her friend Ronald Goldman. After being acquitted of murder, the families of the deceased filed a wrongful death suit against Simpson and attained the judgment against him to the tune of $33.5 million, despite Simpson being acquitted of criminal charges. This can happen because civil and criminal cases differentiate in what's called their standards of proof. In a criminal case like the Simpson murder trial or the misdemeanor battery charge that won't be filed against Iron Mike, a prosecutor must demonstrate beyond a reasonable doubt that the defendant has committed the crime they're being accused of. On the other hand, in order to prove a civil claim, a plaintiff is only required to prove his case by the preponderance of the evidence, which is a lower standard than the burden necessary to prove a criminal case. Under the preponderance standard, a person is only required to prove to the court that based on the evidence available, their claim is more likely than not true. Next up, New York County Supreme Court Justice Felicia Mennin ordered 26-year-old Lauren Pazienza to be held without bond following a request by prosecutors at her arraignment. Pazienza has pleaded not guilty to charges of manslaughter and assault and is accused of shoving 87-year-old singing teacher Barbara Guster into the ground, ultimately killing her. Pazienza was previously out on a bond of $500,000, prompting her defense team to argue that because no new facts had come to light, there is no justification for the alteration of her bail. Her bond was revoked by Justice Mennin after arguments from the prosecutor that Pazienza was a flight risk. After Pazienza allegedly pushed Guster into the ground, she quickly fled to her parents' home and deleted all of her social media accounts. How foolish could she be? After police came to her parents' home, she chose to turn herself in. As a result of this incident, Pazienza is making headlines across the world in the worst possible way. Look, in Pazienza's defense, she was just following Iron Mike's way, right? Not at all. This isn't Justice Mennin's first time making headlines either. In 2017, Judge Mennin was caught in a verbal altercation with another Manhattan judge, Anthony Ferrara, who interrupted her proceedings in search of an attorney. An expletive-laden exchange between the judges prompted Judge Ferrara to be banned from the bench for the final month leading up to his retirement. I would have loved to have been in that courtroom for that. On the topic of brutal murder, attorneys for the family of Toby Al-Salimi have released a statement claiming that his girlfriend, Instagram model Courtney Clenney, will be arrested in connection with his murder by stabbing. No charges have been filed yet, and the Miami-Dade Police Department has refused to comment on their ongoing investigation. Interestingly, a statement was made by Clenney's attorney, Frank Perito, who explained that the situation is unfortunate for everyone involved, and that the police investigation will reveal that Clenney was acting in self-defense. Clenney's attorney further asserted that it is irresponsible of the Obasalmi family attorney to claim that Clenney was an instigator or that she is being afforded any special treatment. While no arrests have been made and no charges have been filed yet, it is clear that positions are already being drawn out in this dispute. Effective criminal investigators will focus on maintaining positions as fact finders and will seek to eliminate any doubt that may exist that a suspect committed a crime before filing charges. While it remains to be seen what the truth of the scenario is and what the outcome may be, both parties have followed the golden rule and chosen to seek counsel in an effort to effectively present their case. Remember, don't be an internet lawyer.
Don't be a lawyer.
Yahoo Answers is not the same as a law library. You guys remember Yahoo Answers, right? Whosever idea it was to shut down the website that gave us gems like these should be fired. Now, in another case, the Supreme Court unanimously ruled that the city of Boston must permit a religious group known as Camp Constitution to fly a Christian-themed flag outside City Hall as a part of their city program that allows private groups to use flag space. In this case, Justice Breyer delivered the opinion which explains that allowing private religious organizations to participate in government programs that allow the display of symbols does not constitute government speech, which generally means that if the city of Boston permits private organizations to fly flags on the property of City Hall, it must indiscriminately permit groups to fly flags at City Hall without respect to their affiliations. The court reasons that because the city of Boston's practice was to approve flag raisings without exception, the city government itself was not participating in a form of government speech. Carefully, Justice Breyer explains that had this incident constituted government speech, the city would have been well within its rights to restrict the speech.
Did you know that you have rights?
Now, as you can see, the law is all around you. Next up, we have an amazing interview with somebody you won't believe what's going to happen. We have great insights into the dating world. You'll see the legal implications all over the place. As you saw in one of our stories, be careful who you date. You don't want to get murdered. And we'll keep hitting on these media events on a weekly basis as well. And because of everyone's huge request, we'll be focusing on cyber privacy and security issues also.